you must always use the American passport. Exiting the U.S. or entering the U.S., always use the American passport. When you travel outside the U.S., you may use the other passport.
Thank you so much. Now, Attorney Golan, an individual is very worried about her residency because she's receiving benefits, like for healthcare, for food stamps, etc. Will this affect her application for naturalization if ever she applies for citizenship?
They might. They might. It depends on the circumstances, on her circumstances. It depends on how long she has been a resident. It depends on the exact type of benefits she receives. So it's impossible to give an answer over the telephone like this. She will need to consult with a lawyer and provide many more details about her circumstances.
And is an affidavit of support still a requirement for application for residency or citizenship, Attorney Golan?
Not for citizenship, but for permanent residency, yes. And a very strict requirement.
Is there a particular detail that has to be considered? Meaning, from whom can they get the affidavit of support, Attorney Golan? Has to be a close relative, or the employer, or a friend?
The affidavit of support in employment-based cases, the employer is not required to give an affidavit of support. But in family cases, the petitioner is always required to give an affidavit of support, even if the petitioner doesn't make any money. And in that case, the petitioner may provide an additional person, maybe a friend, maybe a relative, not necessarily a relative, to provide a supplemental affidavit of support.
And you're listening to Immigration Update on the Air, and we're looking through these questions that were called in, and we're asking Attorney Golan, who is our immigration lawyer today on Immigration Update on the Air. By the way, you asked for the address. It's 3250 Wilshire Boulevard. That's Suite 1918 in Los Angeles, California. And you can call him immediately for a schedule for an appointment at 213-383-3222. Attorney Golan, here's a question from someone who had stayed in the United States for several years, undocumented, illegally, and decided to go home. Of course, without the intention of returning back to the United States, because as she understands, she will have a 10-year bar. I don't know if that's correct. But anyway, recently she communicated with us and said that there is a chance that the husband can become a Spanish citizen. Apparently, there's like this privilege given to descendants, people who have grandparents who are of Spanish origin that can apply at the Spanish embassy and can become Spanish citizens. So now they're in the process of applying. The question of this wife is, if the husband obtains Spanish citizenship, and then she is petitioned and also becomes a Spanish citizen, can she also use that citizenship to go to the United States and visit, although she has a record in the past that she stayed illegally in the U.S. for many years?